I'm Dave Dinkel, and what you've heard about the law has caught up to me is absolutely true. In this situation, what's happened is I've always said to people, if you have a contract that you can assign it, not assign it, or assign it with liability, the agents are always going to check you may not assign. But if you check none of those boxes when you submit a contract, you can assign the contract. My stipulation has always been that if you have those choices, but you do not check any of the boxes, therefore you can assign the contract. Or in other words, if the contract does not stipulate that you cannot assign it, you can assign it. And lo and behold, I've had probably 100 attorneys disagree vehemently with me, and I've probably had 500 just as vehemently agree with me. So it's always been a bone of contention of, is it true or isn't it true, despite showing statutes and going through various things. People disagree, and that's what the law is for. Courts decide those things. But we've used it for many, many years, and it works very well. Now, how many times do we actually use that to assign a contract? Barely, ever, rarely, or none at all. Why? We don't assign contracts. We don't make minuscule profits. We don't make profits where you can't make a living on the deal. You shouldn't be doing them if you're going to make that kind of money, because the guy buying the property from you is going to resell it and make from 5 to 50 times probably the profit he gave you. So let's go back. We're talking about the law has caught up to me. What does that mean? In a conversation with my attorney today, he said to me, did you see what the new proposals for the state bar and Board of Realtors contract is? And I said, no, I don't look at that. When it finally is approved and comes out, we look at it to see what new changes or clauses we have to add to, again, protect ourselves. He said, well, they finally agreed with you about not checking any of the boxes. In fact, allows you to assign the contract. I said, no kidding. He said, yeah, they've added, or they propose to add language that says if none of the boxes are checked, then it automatically defaults to it's not assignable. What does that mean? It means that they've finally come to their senses about they agree with what I said. So the law has caught up to me again. It's not the first time. Another time that took a long time for him to catch up to me, so to speak, is I'd always have a student or myself put into any kind of short sale contract a clause that basically said the inspection period starts when you get lender approval in writing. So what's the difference? Well, typically, when you sign a contract, the last signatory to the contract makes the contract go into effect. So if you signed a short sale contract with a homeowner, it was automatically in effect and your inspection period started that day or the next day. Well, what happened when 3 to 6 months later you got a short sale approval? You went out to the house and there's no doors, no windows. The house is blown away or it's just been vandalized. There's no metal in it. You go back to the listing agent and you say, look, things have changed. He says, look, you signed the contract. But before you signed the contract, you said to him, what happens if something happens? He would say to you, oh, not to worry. We wouldn't do that to you. Well, that's not what the contract said. So I would add that simple clause that says inspection period starts with lender approval in writing. I did that for years, and finally the Board of Realtors and the Bar Association said, add that into the short sale addendum contract. They agreed with me again. So the law has caught up to me once again, and I look forward to being caught up to in the future. I'm Dave Dinkel. I wish you limitless success in all you do, and give me a thumbs up and pass this on to people. Help them out too. Thanks again.